All right, hey Spanish Springs. Let's get into day 2 of the lecture notes. This is pages 4 through page 6. So 0 period, I think this is the same for you, this whole lecture, so you have the same material on the same day. All right? As we continue on in the courts. So I think the first part, this Roman numeral 1, talks about the federal attorneys. And so what we have to look at is we kind of have to bring back the bureaucracy. What we have in the bureaucracy is we have the Attorney General. The Attorney General is the head of the Department of Justice. So while we call people like the head of the Department of State, the Secretary of State, the head of the Department of Treasury, the Secretary of Treasury, the one of the 15 cabinet leaders that we call something different is the Attorney General. But the Attorney General is essentially the Secretary of the Department of Justice. We just call them the Attorney General. And really, I think a good way to look at them is that they are the top law enforcement agent in the country for the presidency. All right, and so just like all other cabinet, the top 10% of the bureaucracy, the Secretary or the Attorney General is appointed by the President and confirmed by the Senate. And a simple majority is needed to confirm that. They'll hold hearings in a variety of committees. Probably the Judiciary Committee will hold those hearings to kind of go through the nomination process. Our current our current Attorney General is Eric Holder. I'm not quite sure if the Obama administration is going to keep him or is going to leave. We'll see. All right. Now, the next position kind of within this is the Solicitor General. Now, the Solicitor General is, again, appointed by the President with consent by the Senate or confirmed by the Senate. And what they do is they are the government's lawyer when a case gets to the Supreme Court. So whenever the federal government is part of a lawsuit, the Solicitor General argues the position of the executive branch. And so ideally what they're doing is they're just like the top 10% of any bureaucratic agency. The Solicitor General advocates the positions of the President for whatever the issue may be, whether it be like the current same-sex marriage case that we saw last week with DOMA and Prop 8, whatever the issue is, the Solicitor General argues the President's position on a set of issues in front of the Supreme Court. They're the government's lawyer. All right? Now, below that, we have U.S. attorneys. And U.S. attorneys are the lawyers at the U.S. district courts. Now, if you remember from last time, we have 94 district courts. And in each district court, there'll be a U.S. attorney which prosecutes federal cases for the government at the district court, and then they would also follow it up at the circuit court or the appellate courts of the 13 of those. And then if the case gets to the Supreme Court, that's when the Solicitor General gets in and they argue the case for the government. Now, a couple of other things. The U.S. attorneys have 4-year terms, and I don't want you to be confused, but that concept of senatorial courtesy again applies. We saw that senatorial courtesy applies to district judges. Senatorial courtesy also applies to the U.S. attorneys at the 94 district courts. The president or the executive administration will go to the senators of those states and kind of vet the people they're going to choose to be the U.S. attorneys. I think the notes talk about this as being a key patronage position. It's not that these people can't pass the rule of fitness or don't pass the rule of fitness, but these are quite often viewed as political rewards for being a loyal Democrat, for being a loyal Republican, and in the same time a good lawyer, and have the ability and the prosecuting experience within the legal system. All right, and just as an aside with this senatorial courtesy, remember that I think what it is the president and his staff. I'm not quite sure if the president talks to the specific senators or uses his White House staff to have these discussions. But what they do, if there's going to be a new district judge, or in this case now, a new U.S. attorney in Nevada, what that would mean is the president would talk to our 2 senators right, Senator Heller and Senator Reid, and inform them of the decision of the person that they want to appoint to that position. Now, what I would guess is quite often the presidency or the executive branch may talk to those senators to ask if they have people that they think might be part, or they might desire to be there in those positions. All right? But again, both of them have to go through confirmation. And the other thing about senatorial courtesy is in the Senate itself, if those senators are opposed to who the president chooses as a nominee, we could see, I think, the Senate drag their feet or not take action on those nominations, not hold the hearings and not vote to confirm those people, or even maybe vote them down. So that's senatorial courtesy. All right, applies to both district judges and U.S. attorneys. All right, and then just as an aside too, there are assistant U.S. attorneys who then also are appointed, and they help the U.S. attorneys in the district court prosecute the government's cases at the district court and the circuit court. All right, now let's get into this idea of choosing federal judges. When we talk about federal judges, we mean those Article III courts: district court, circuit court, and Supreme Court. All of those people hold their job for good behavior, which we know, as reading the Federalist 78, translates into life. Now, they can resign, they can die, they can be impeached. Very rarely are judges impeached, and practically there's a handful of them over 200 years have been impeached. Right? They're insulated, they're in there for a life, as we've looked at in 78, to create this judicial independence so they can make decisions that they believe are guided by the Constitution rather than political pressures from Congress, political pressures from the executive branch, and political pressures from public opinion. All right? They make decisions that are controversial, and therefore, according to our framers, according to Hamilton and the Federalist 78, and the idea is life terms give them independence. Now, what I would say is, on the AP exam, they may ask you, what is the term of office for a federal judge? And your answer, and they could put as an option, good behavior, which you're supposed to translate into life. All right, so again, that's district judges, circuit court judges, and Supreme Court justices serve life terms or for good behavior. Now, we've talked about cross-pressure all year. Your own specific ideology and cross-pressure in your voting habits. Members of Congress experience cross-pressure from a variety of interest groups and constituents and all that, think tanks and the media and the executive branch and the bureaucratic agencies, etc. Now we need to think about this idea of confirmation for judges. When a judge is chosen and nominated by a president, they have to go through the confirmation process. Now, one of the things that a president will think about is what's the ideological makeup of the U.S. Senate. If we have a Democratic president and a Republican Senate, they're going to have to appoint somebody that can get through that confirmation. If we have unified government with a Democratic president, Republican Senate, it might be easier to get that nominee through. Now, ideally, the first variable you look at when you as president are choosing somebody is going to be the rule of fitness. Do they have experience on the courts, or at least as a lawyer? Do they have the intellectual ability or capacity to be a federal justice, either at the Supreme Court down to the district court level? All right, so this idea of rule of fitness. But then we need to think about all the other cross-pressure stuff. One is senatorial courtesy. Will the two senators from that state like that person? What's the makeup of the Senate at the time that you're appointing a judge? I think in your examples, now, one of the things you do when you make a list of people to be on judges is they get vetted. And another word for vetted is simply you screen their background. You look in the background for things that could come up that would make them an undesirable candidate and also unable to make it through confirmation. So the American Bar Association, which is essentially the interest group that represents lawyers, has traditionally been the group that presidents will give their selection, their nominees, they will give them to the American Bar Association, and they will vet them. They will give them a score. And that score ranks on everything from experience to previous decisions, and kind of give you an unbiased or nonpartisan rating of that person. Now, in the Senate Judiciary Committee, which holds the hearings for these confirmations before it gets sent to the floor for a full vote, they use these ABA ratings as well. And if you have low ABA ratings, you might not make it through the process. If you have high ABA ratings, it shows that you're passing the rule of fitness. The Bush administration had in the past not only used the ABA, but they used something called the Federalist Society to vet their judges. Now, the Senate didn't really use these, but the Bush administration felt it was important. They wanted to put judges on the bench that they felt would interpret the Constitution in the manner in which the conservatives liked the Constitution be interpreted. Now, this is sometimes seen as textualism, strict constructionism, kind of a narrow interpretation of the Constitution that they attempt, which is very difficult, but to find the values or beliefs of the framers when they wrote that Constitution. And the Federalist Society was a conservative group that had these values: smaller federal government, more states' rights, a high stress on individual liberty. And so the Bush administration not only used the ABA, but also used the Federalist Society for their own internal kind of vetting of these justices. Did they have a track record of conservative interpretation of the Constitution? Because remember, once these judges are put onto the bench, they're essentially there for life. So a president doesn't really have control over their decisions, right? Once they're there for good behavior, and they can't be fired for unpopular decisions. And we have numerous examples in American political history in which a Republican president has appointed what they believe to be, a moderate to conservative justice. When that justice gets onto the bench, they've become more liberal, or they've decided their views have changed because they are free to do that once they get there. Now, the nomination process itself in the Judiciary Committee used to be guided by rule of fitness. But I think, and I don't know when to give this a date or say it starts, but I think a lot of people will think the Bork hearings. The first President Bush appointed a man named Robert Bork, who was very outspoken and very conservative in his beliefs. And he essentially got hammered by the Democrats on the Senate Judiciary Committee. And since that nomination process, we've seen the hearings become highly political. Ideally, judges are impartial referees of the Constitution, but more and more, we're seeing the Senate kind of asking them political questions, partisan questions, trying to see, how would you rule on abortion? How would you rule on gun control? Rather than just simply, what are your beliefs? What's your experience? It's more trying to get them to say what they would rule or how they would rule on certain issues. So it's become highly political. I think the other thing is Clarence Thomas, another Bush the Elder appointee, who went through an incredibly rigorous screening or hearing through the Judiciary Committee, to the point where the Republicans accused the Democrats of a high-tech lynching. And I think we know that lynching in American society has, very, very, very negative connotations. When you use that word lynching, we bring up kind of the racial element. And Clarence Thomas is black and was black when he was nominated. And then we even get what ends up happening is we get the Souter solution, which is David Souter was a nominee from a Republican president who generally didn't have a lot of background, didn't have a lot of writing. They called him the stealth candidate, meaning you couldn't pigeonhole him or pin him into a conservative or a liberal, which to get through the hearings and the confirmation was great. But as a justice, if you're a president appointing him, you're not quite sure how he will rule. And in fact, David Souter ended up being a pretty liberal justice, much to the chagrin of the Bush administration. Now again, the Senate can use holds. The Senate can filibuster nominations. They can use a hold on the vote. They can use a filibuster to block a vote from going forward. All right. Now you also want to think it needs a majority to get confirmed. All right, and then here's the idea of all these cross pressure variables again. Ideology is important. Presidents generally tend to appoint somebody who is ideologically similar to them. That's how they want the Constitution interpreted. We also look at their paper trail, meaning if you have previous decisions as a lawyer previous writings as a lawyer, previous decisions as a judge, those writings are going to come to your hearing where they're going to ask you questions. Did you mean this when you said the Equal Protection Clause meant this? You know, they have things on abortion, things on gun control, things on executive power, you know, things on congressional power, things on executive orders, all the things we've talked about. The paper trail means they have a track record of how you might vote. And so some people can use that paper trail and say, look how good you are. And then those political opponents may use it against you to try to not get you confirmed. I think age is an important factor. Remember, they serve for life. If you can get, there's no constitutional requirement, I believe, for age. But what we know is we generally think of a judge as somebody who's been around a while, some wisdom. And so the key here, though, is if you are, say, 50, you've got a good 25, 30 years on the bench. And for a president appointing you to the courts, that means their legacy exists on the courts for that long. If you know you're 75 when you get confirmed, you know you probably don't have that long to be on the court, and therefore they may not choose you if you're too old. Now, too young means you're probably not experienced enough. Maybe smart enough, but just not experienced enough. Now, also race. Thurgood Marshall was the first African American to sit on the Supreme Court. And when Thurgood Marshall died, there was a dilemma. Thurgood Marshall had voted liberal. He was a liberal justice. He was one of the lawyers in the Brown v. Board case, so we knew how he was going to vote. But you had Bush the Elder had a dilemma. You have the first African American seat on the bench, which is pretty historic, right? And so they had this dilemma of, we know that maybe the American public expects an African American to take that historic seat. However, if we look at the data, African Americans tend to be Democrat. So for the Republicans, they wanted to find somebody that was conservative, but maybe filled that legacy of Thurgood Marshall. And so Clarence Thomas was the nominee. And like I said just a few minutes ago, he went through a pretty intense screening, but he was ultimately confirmed. And therefore, you kind of had this thing where they had the African American seat preserved, but at the same time, you know, Justice Thomas has been a conservative on the bench his whole life. So they kind of fulfilled that. The other thing is gender. Sandra Day O'Connor, appointed by Ronald Reagan, was the first woman on the bench. And she retired a number of years ago to take care of her husband who had Alzheimer's. And then the dilemma was, should that seat be filled by a woman? Now, at the time, we still had Ruth Bader Ginsburg on the bench, so there was already a woman on the bench. So Bush Jr., where that vacancy came up, appointed Sam Alito, and then eventually when John Paul, I don't know if it's John Paul Stevens, I'm forgetting here, he had a second opening, and he appointed Sam Alito and John Roberts as the Chief Justice. But we still have Sandra Day O'Connor. Now, gender-wise, Barack Obama has appointed the former Solicitor General Elena Kagan to the bench and Sonia Sotomayor to the bench. So at this moment, we have 3 women, 1 African American, and the rest white male Protestants or white males at this point. All right. So again, ideology, race, sex, political party, paper trail, the rating from the American Bar Association are all factors in choosing a president or choosing a nominee for either the district, circuit, or Supreme Court. Obviously, with the Supreme Court being the most sought after, the highly scrutinized by the Senate. All right. So think cross pressure, life terms. Now, the other thing on page 6 is. And we will respond with checks that the President and Congress have on the courts later. But one other thing on number 10 on page 6 is the Supreme Court, and we looked at Article 3 the other day, is the only court created in the Constitution. So what that means is, and the language we saw is all other inferior courts were created by legislation, by statute, by Congress. So and also, they can increase the number of courts, decrease the number of courts at those lower levels, not the Supreme Court. They can change the number of justices through legislation. The Constitution doesn't say 9. So sometimes one of the checks that, well, not sometimes, not it happens, but it's potential. If Congress doesn't like the Supreme Court's decision making, what they can do is lower the number of justices. So when one dies, one resigns, retires, then that justice isn't filled. So you don't give a president who may be of the opposing party the opportunity to get that ideology back into the court. And we also know the famous court packing scheme in which FDR was having New Deal legislation struck down again and again and again by a conservative Supreme Court, and he threatened to add justices. And if he added justices, he had Democratic Senates, and so adding justices, he could get the votes he needed to pass and uphold that New Deal legislation. Now, historical things happen and that wasn't necessary, but remember that even though FDR threatened it, he needed congressional support to do that. Congress is the one that can change the numbers. All right? So again, let's see, should I give you some extra credit though for watching this thing? How about who's the new pope? All right, I'll put that on the quiz. We got to see who the new pope is. I know that we got white smoke today, so we know that there's a new pope. I know he's from Argentina. I'm not quite sure what his name is. Okay. All right, Cougars, I'll see you next time. Lecture 2 done.